another episode of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 138 of the Forge of Freedom. Today I've got an update regarding the Rahimi decision, which was just handed down by the Supreme Court on Friday. Would have been this. I'm recording this Sunday, June 23rd, so it would have been Friday, June 21st. The Supreme Court handed down their opinion in an 8-1 decision. The lone dissenter was Justice Clarence Thomas, and the majority opinion was written by Chief Justice John Roberts. And the moment that I saw that the opinion had been written by Chief Justice John Roberts, I knew that it was not good for the Second Amendment. I just didn't know how bad it was going to be. There are a number of commentators out there in the Second Amendment world that are painting this as a victory. This is not a victory at all. It's just not as bad of a loss as it could have been. Of course, if the government had gotten everything they'd asked for, it would have been very bad, a very bad loss. But it was still a loss, nevertheless, just not as bad as the government would have liked, at least for the Second Amendment. So just for a little background, for those who don't know, Rahimi is a case challenging the constitutionality of a federal statute, 18 U.S.C. 922 G8, which prohibits the possession of firearms and ammunition by someone subject to a domestic violence restraining order. Now, I'm going to put that statute up here shortly, but before I do, I just want to give a quick background and a synopsis about where we are with respect to Second Amendment litigation, at least at the Supreme Court level. So in 2008, the United States Supreme Court decided the Heller case, which was the first case decided by the Supreme Court that interpreted the Second Amendment to protect an individual right, not some collective right that had required participation in the militia or something like that. Okay, the Supreme Court in 2008, in a 5-4 decision, so it was a very close decision, decided or opined that the Second Amendment protected an individual right. But remember, the Bill of Rights was, when it was adopted, only applied to federal government action. And in 2008, that case, the Heller case, was a case involving a law in Washington, D.C., which was a federal enclave. So even though the Supreme Court opined that it was an individual right, it was only an individual right that was protected with respect to federal government action, at least in 2008, because it had not been incorporated. And incorporation doctrine is a whole nother rabbit hole to go down and talk about. But it had not been incorporated to apply to state government action. And that remained the case until 2010, when the Supreme Court decided the McDonald case, which challenged a law in the city of Chicago. And in that case, the Supreme Court said not only does the Second Amendment protect an individual right, it protects an individual right with respect to federal government action and state government action, because this is a law, remember, in the state of Illinois, in the city of Chicago. And so the Second Amendment became incorporated to apply to state government action as well as federal government action. That was in 2010. And from 2010 until 2022, there was no Second Amendment case that had reached the Supreme Court. And that's probably because of the composition of the court. Remember, the Heller decision was 5-4, and then when Donald Trump became president in 2016, he nominated a number of justices to the bench, Gorsuch and Kavanaugh and Barrett, in particular, Amy Coney Barrett. And so the composition of the court changed dramatically. And so that set the stage for the Bruen case to reach the Supreme Court in 2022, which challenged the law in New York that required someone to show good cause to obtain a license to carry a firearm. And in that case, the Supreme Court, in their opinion in Bruen, overturned the law in New York, clarified the methodology that courts should apply to challenges based on the Second Amendment, challenges to laws burdening the right to keep and bear arms based on the Second Amendment. And in that case, they said, listen, we said this in Heller, we're clarifying that courts should not be applying an interest balancing test when analyzing challenges based on to laws based on the Second Amendment. So prior to 2022, many courts were applying various levels of scrutiny when reviewing challenges based on the Second Amendment. Oftentimes, the law is upheld and the government prevails in those challenges, because what happens is they consider what is the burden on the right and what is the government interest in burdening that right. And surprise, surprise, the government and government judges often err on the side of the government in that interest balancing analysis. And the Supreme Court said, no, we're not engaging in that interest balancing anymore. That's not how we're supposed to interpret the Constitution. The Constitution was adopted as a compact between the states, and we should analyze it based on the original meaning that was understood at the time that it was adopted. And if the states want to change it, they can change it. But insofar as they have not changed it, we should interpret it based on its original meaning, the original meaning that compact had when it was adopted. And to do that, we review challenges based on the Constitution and the Bill of Rights by what's called the text, history, and tradition. So we look at the text of the Constitution, or in this case, the text of the Second Amendment. We look at the history of the right and the tradition of the right and any relations or laws with respect to that right at the time that the Constitution and the Bill of Rights were adopted. Now, there's some question about whether the courts can look to later law, like the post-Civil War law after the 14th Amendment was adopted, because that's when the 14th Amendment, through the Privileges and Immunities and the Due Process Clause, that's where a lot of the Bill of Rights started to become applied to the states, not just to the federal government. So there's some question about whether it's appropriate to look to that later history. And I think that it is, but only as confirmation of the understanding of the law, the text, the history, and the tradition at the time of the founding. So that's what Bruen said. We don't get to. It's not appropriate to engage in this interest balancing, because that interest balancing was done at the time that the Constitution was adopted and at the time that the Bill of Rights was adopted. And so if the states want to re-engage in that interest balancing, they have to do so by amendment of the Constitution, not through judicial activism. And so in the wake of Bruen, there have been many courts who have been resistant to that text, history, and tradition analysis. There have been others who have maybe not been so resistant, but not sure what the nuances are of that analysis. And so there had been some hope that the Supreme Court would take up another Second Amendment case to analyze this issue and to clarify how to apply that text, history, and tradition analysis. And the court in Bruen said that to engage in this analysis, we have to find, well, let me back up. If someone challenges a law based on the Second Amendment, the court will first look to the plain text of the Second Amendment. And if the plain text of the Second Amendment applies to the law that's being challenged, then the burden shifts to the government to show that the regulation or the restriction on the right is consistent with the text, history, and tradition of the Second Amendment. And they have to do that by analogical reasoning. And the analogical reasoning, they have to look to laws at the time of the founding and regulations and see, was there a law or regulation at the time of the founding that was relevantly similar to the law that's being promoted or enforced by the government. And so the question is, how close does that analogous law have to be? What does relevantly similar mean? Does it have to be almost identical, or can it be more broadly similar? And so that's an issue that the Supreme Court really left open in the Bruen decision. And so when the Rahimi case came before the court, the Supreme Court was going to have to engage with that to some degree. And Rahimi, just to give you a little bit of background, is a case that the Merrick Garland, the Attorney General, and the Department of Justice pushed to the Supreme Court because Zaki Rahimi was not, by any stretch, a favorable plaintiff. He was a bad dude. And Zaki Rahimi, he was a drug dealer. He'd engaged in, apparently, a number of violent acts. But he was also subject to one of these domestic violence restraining orders contemplated by federal statute under 18 U.S.C. 922 G8. And I'm going to put up the statute here on the screen for those of you watching by video. Again, this is 18 U.S.C. 922 G8. And it says, "It shall be unlawful for any person who is subject to a court order that was issued after a hearing of which such person received actual notice and at which such person had an opportunity to participate." So that's the first component. B, restrain such person from harassing, stalking, or threatening an intimate partner of such person or child of such intimate person, or engaging in conduct that would place an intimate partner in a reasonable fear of bodily injury to the partner or child. Second component. And third, includes a finding that such person represents a credible threat to the physical safety of such intimate partner or child. And so that's the statute that was being challenged here. The court didn't address this C2 provision. I think to just address, the court only decides issues that are before it, and they declined to opine on the constitutionality of C2, but I think C2 would have been determined to be unconstitutional if they had, because it says, by its terms, explicitly prohibits the use, attempted use, or threatened use of physical force against such intimate partner or child that would reasonably be expected to cause bodily injury. And that doesn't require any finding that the person is an actual threat or a credible threat to anyone. So I think that C2 provision would certainly have been determined to be unconstitutional, but the court didn't decide that. So the Attorney General pushes this case to the Supreme Court because they think this is the best chance we have to water down the Bruen methodology, because here we have a plaintiff, Zaki Rahimi, who nobody likes. And so we're going to force the Supreme Court into a position where they have to decide how strictly they're going to construe their or utilize the Bruen methodology that they laid out in 2022. Because I think if the court takes a more narrow approach, a more originalist, a more faithful approach to the Constitution and the Bill of Rights, I think the statute is clearly unconstitutional, because these orders, even if they're issued after a hearing, after notice, they're only by a preponderance of the evidence. And there is simply no historical analog that would deprive someone, even temporarily, of their right to keep and bear arms, subject to a criminal penalty after a preponderance of the evidence. And so, in looking at the history, the court was offered two analogs that they considered. The first were what were called surety laws. And surety laws operated for the same purpose as 18 U.S.C. 922 G So the same why, the same purpose, but they operated much differently. So a different how. So whereas 922G8 deprives the person of the right to keep and bear arms if the order is issued, you can't possess, you see here in the statute, you're prohibited from shipping or transporting interstate or foreign commerce, or possessing in or affecting commerce any firearm or ammunition, or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. So 922G8 prohibits the possession and subjects the person who violates it to criminal penalty up to 15 years in prison. Whereas the surety statute, what it did was it required the person who was determined to be a credible threat to post a bond. And so they did not lose their right to keep and bear arms. They were still allowed to keep and possess arms, but if they did violate the order, they would forfeit the money. Okay? They would lose the money. There'd be a fine, a penalty, but they did not lose their fundamental liberty interest in the right to keep and bear arms. So you can see here, while it's analogous in the purpose, the mechanism by which it's implemented is far different. So if the court is going to adopt surety laws as an analog, what we see is that the court is looking at analogs that are far more generally similar, not closely similar. Okay, so that's the question. How close do these analogs, do these historical analogs have to be? And we got an answer here with the Rahimi case. To some degree, they declined to parse out the nuances of the generality that would be sufficient, or the applicability of these historical analogs. But they gave us some idea by saying that surety laws were relevantly similar analogs, because frankly, while, like I said, they're similar in the why of the law, to protect people from credible threats of violence, the how is extremely different. Okay, so the next example they use is what's called an affray. And an affray was basically a law that prevented people from terrorizing the public by going armed with dangerous and unusual weapons. Okay, so it was a criminal violation to violate laws against affray. And so again, similar purpose, but a far different implementation. It's a criminal statute. You have to be found guilty of an affray to be deprived of your right to keep and bear arms. It doesn't prevent you from bearing arms at all. Only prevents you from going and bearing arms in a way that terrorizes the public, okay, with dangerous and unusual arms, okay. So the court, and we'll get into the opinion here in just a little bit, use those two analogs to say that 18 U.S.C. 922 G8, as applied to Rahimi, was constitutional. Now, there have been lots of folks out there say this is a very narrow opinion, and the Bruen methodology is still left intact, but as applied to Rahimi, this statute is constitutional. Well, again, this is going back to my point earlier. That's true to some degree, but by choosing these two analogs, the surety statute and the affray, the court has given us an idea about what level of generality they're willing to look to for analogs to modern historical, or to modern regulations on the right to keep and bear arms. And so I'm afraid that where we have two what I consider to be very different laws and in the surety statutes and in the affray, that the level of generality that the court has utilized here will set the stage, will set the precedent for courts to uphold many gun control regulations that I consider to be unconstitutional. And so in that way, I think I think that Rahimi was a significant step back in terms of protecting the right to keep and bear arms. And I think that while it could have been much worse, it's certainly a loss for the right to keep and bear arms and for individual liberty going forward. So with that being said, let's get into the opinion here just a little bit. And again, like I said, this opinion was written by Chief Justice Roberts, which I knew was going to be problematic because Chief Justice Roberts is he's very concerned with the reputation of the court, and I think that he would have been reluctant to find in favor of Rahimi simply based on Rahimi's reputation. And that's exactly the opposite of what our justice system is supposed to do. Remember, everybody learns in their basic government class that the justice is supposed to be blind, and that justice simply looks at the law and the facts before it and doesn't make political calculations. But I think that's exactly what this is. I think this opinion is it's politics with the pretext of originalism. I think that's exactly what this is. And I don't think the opinion, despite all of the discussion about originalism and text history and tradition, I don't think it is very originalist at all. Like I said, because the level of generality that they utilized to review the historical precedent for 18 U.S.C. 922 G8 was far too broad, in my opinion. So I've got the opinion. This is the highlighted opinion up on the screen. You can see a lot of my highlights here. A lot of people have talked about the problem here is due process. Well, I just want to say at the outset, Rahimi waived that argument. Okay, and I get that due process is a problem in lots of these protective order cases because a lot of times they're just issued as mutual protective orders in a domestic relations case, or they're often issued with very little evidence, or even if you have a hearing, the judges err on the side of caution and issue these, sometimes without an attorney, because these, remember, are civil protective orders. And so there is no right to an attorney in these protective order proceedings. And so I think that there certainly are due process concerns, but that was not an issue in this case because Rahimi waived that. He didn't raise that issue on appeal. And if you don't raise that issue, you waive it for the purpose of further appeal. So that issue was not raised here, and the court didn't address that issue. But here you can see on the first page, held in green, I've highlighted, when an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment. And the court goes on here, as applied to the facts here, Section 922 G8 fits within this tradition. And one of the things that was positive about this opinion, and this is a very small victory, but the government in oral argument was saying that people who aren't, they were basically equivocating between responsible people and irresponsible people and dangerous people. So they were saying, what they were suggesting was that if you're not responsible, you should not be able to enjoy the right to keep and bear arms. And so this question, the justices ask these, well, what if I'm speeding? Does that make me irresponsible and forfeit my right to keep and bear arms? And so I think that was trying to bite off too much there. And thankfully, 8 justices, actually all 9, rejected that particular argument, even the liberal justices on the court. So that's not an issue. But nevertheless, we got a pretty broad interpretation of what analogies are applicable or are relevantly similar for the purpose of a Second Amendment analysis. In this part, I want to point this out here. I already gave you a little background that the court goes into the surety statutes and the going armed laws, or the affray laws. But they say, well, while they're distinct from 18 U.S.C. 922 G8, the court says together, this part's important, together the surety and going armed laws confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. Section 922 G8 is not identical to these founding era regimes, but it does not need to be. Like the surety and going armed laws, Section 922 G8 C1 applies to individuals found by court to threaten the physical safety of another. This prohibition is relevantly similar to those founding era regimes in both why and how it burdens the Second Amendment right. And that's what's interesting here. It's not similar on the why and the how with respect to either. In the court here, and Justice Thomas points this out in his dissent, he says together, the court says together they're relevantly similar. And so what they're doing is they're mixing attributes of both to come up with a morphed analog that would be similar as to the why and the how. Okay, so they're mixing attributes of a phrase and attributes of surety laws to come up with an analog that is at least somewhat similar. I wouldn't even still say relevantly similar to the 18 U.S.C. 922 G8 prohibition. And that's, as Justice Thomas points out, is not how the originalist approach to interpreting challenges to the constitutional challenges works. And we'll get to that here in just a little bit. And here again, this is page 13 of the opinion. Taken together, the surety and going armed laws confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. Section 922 G8 is by no means identical to these founding era regimes, but it does not need to be. Its prohibition on the possession of firearms by those found by court to present a threat to others fits neatly within the tradition of surety and within the tradition that surety and going armed laws represent. And interestingly, the opinion here of the court is only 17 pages in length. 18 pages. It goes on to the 18th page. The entire opinion with the concurring and dissenting opinions is 103. So you'll see that there are significant concurring and dissenting opinions here. If you go check this out, and I'll link to the opinion in the show notes. But the opinion itself that 8 justices signed on to is only 18 pages. And so in that sense, it is a relatively narrow opinion, because they avoid lots of questions that were raised about 18 U.S.C. 922 G8. But before we move on to the concurring and dissenting opinions, I just want to briefly mention here, Chief Justice Roberts mentions the dissent, and he says the dissent reaches a contrary conclusion, primarily on the ground that the historical analogs for Section 922 G8 are not sufficiently similar to place that provision in our historical tradition. The dissent does, however, acknowledge that Section 922 G8 is within that tradition when it comes to the why of the appropriate inquiry. The objection is to the how. For the reasons we have set forth, however, we conclude that 922 G8 satisfies that part of the inquiry as well. As we said in Bruen, a historical twin is not required. And I think that's the opinion here criticizes the Fifth Circuit for making the same error. But the Fifth Circuit and Justice Thomas are not looking for historical twins. They're looking for laws that were relevantly similar as to the why and the how. And there simply is not one. Okay, the surety laws, completely different, totally similar as to the why, completely different as to the how. Affray laws, somewhat similar as to the why, although it was with respect to the public at large, not with respect to individuals who were being threatened. Again, totally different as to the how, because it was a criminal statute. So here we have two laws. The closest examples are totally different as to the how. So not only they're not even close to twins, all right, and the courts, the Justice Thomas and the Fifth Circuit weren't looking for twins and explicitly said so. Justice Thomas wrote the Bruen opinion, and he's the one who said the inquiry doesn't require an historical twin. Okay, he's the one who wrote that opinion. So he's not holding himself to a different standard than the one that he wrote in Bruen. This is just absurd in my mind. Okay, so let's get into some of the concurring opinions here. And I don't want to belabor this too much, so I'll try to make this relatively quick. I want to talk more about the dissent, because I think that Justice Thomas, unfortunately, is the only one who got this right. But unfortunately, the dissent is not binding in any way. But he says, or actually here in the first concurring opinion by Justice Sotomayor, she says, and this is concerning, rather than asking whether a present-day gun regulation has a precise historical analog, courts applying Bruen should consider whether the challenged regulation is consistent with the principles that underpin our regulatory tradition. The law must comport with the principles underlying the Second Amendment, but it need not be a dead ringer. Here, for example, the government has not identified a founding era or Reconstruction era law that specifically disarmed domestic abusers. And this is the part that's concerning. Although 922 G8 is by no means identical to the surety, and nobody thinks that it should be identical, but it should be similar, right, as to the why and the how, and it's not similar at all as to the how. So although 922 G8 is by no means identical to the surety or going armed laws, it restricts gun use to mitigate demonstrated threats of physical violence, just as the surety and going armed laws did. That shared principle is sufficient. And we're going to see that again and again to rubber stamp gun control laws. The principle of preventing threats of physical violence that principle, that underlying principle, is sufficient enough. And you see that this watered down analogy based on principle, I think, is going to come up again and again. In fact, if you search for the word principle, it shows up 44 times in the opinion, and a number of times in the opinion by Chief Justice Roberts, and again in the concurring opinions. And I think that that's going to be problematic, and I think lots of the more liberal jurisdictions and the courts in those jurisdictions are going to rubber stamp gun control laws based on the principle of deterring threats of violence. The other thing here, and I skipped this part, I should go back to it. Page 7 of the opinion of the court, this is going back to Chief Justice Roberts. These precedents were not meant to suggest a law trapped in amber. I can't tell you how many times I've seen that already, this law trapped in amber language. And I think we're going to see it again and again and again in future cases upholding gun control laws. And like I said, this opinion is politics under the pretext of originalism. But it's not originalism when you're saying that precedents were not meant to suggest a law trapped in amber. Okay? What that means is it's a reference to these creatures that were preserved in tree resin. Okay, you see these, and I'll just put up a picture here. I think I've got one saved. Here we go. Ancient organisms had been preserved in this hardened resin from evergreen trees. And so that's what the reference is here for a law trapped in amber. It's not frozen in time, the law and the precedent. And so I think that language is going to be used time and time again to basically support not originalism, but this living constitutionalism. So basically the idea that judges can interpret the law based on their own policy preferences because the law isn't trapped in amber. So I think that language from Chief Justice Roberts is going to be utilized by liberal justices, liberal judges around the country to uphold gun control laws. And you'll see amber is used 6 times in this opinion. It's used here in Sotomayor's concurring opinion. Bruen was not meant to suggest a law trapped in amber. It's used in the Gorsuch concurring opinion. Okay, so this is a phrase that's utilized multiple times in this opinion, and I think we'll be hearing more and more of in the future. But this, like I said, that shared principle that it restricts gun use to mitigate demonstrated threats of physical violence, that shared principle is sufficient. That is such a broad reading of the text, history, and tradition that you could uphold a judge, an activist judge could uphold nearly any gun control law, whether or not it actually has any effect, most of which do not. And the Sotomayor concurring opinion here says, if the dissent's, of course referring to Justice Thomas, interpretation of Bruen were the law, then Bruen really would be the one-way ratchet that I and other dissenters in that case feared, disqualifying virtually any representative historical analog and making it nearly impossible to sustain common sense regulation necessary to our nation's safety and security. Yes, that's exactly right. Bruen and an originalist understanding of the Constitution would do exactly that. Okay, it would disqualify and most historical analogs and make it nearly impossible to sustain common sense regulations, because modern gun control far exceeds the bounds and the scope of almost all historical analogs, so that none of them would be relevantly similar, because the government that the founders, remember, were trying to protect the right to keep and bear arms. They didn't want common sense regulations necessary to our nation's safety and security. Okay, that wasn't part of their psyche. They were concerned about those sorts of regulations, right? Which is why the anti-federalists insisted on the inclusion of something like the Second Amendment. And one other thing I wanted to point out here from Sotomayor's concurring opinion is she says Section 922G8 should easily pass constitutional muster under any level of scrutiny. I actually think this is an interesting question. The court rejected, as I said earlier, the tiers of scrutiny analysis in Bruen, and said that the courts should utilize this text, history, and tradition analysis because the balancing test had already been done at the time of the founding. But what's interesting is that if a court applied strict scrutiny to 922G8, it's not clear to me that 922G8 would be constitutional. So it's possible here, and this is a bit ironic, that we have a law here that was upheld under the text, history, and tradition analysis because the court utilized analogs at a very general level that might not have been upheld under a strict scrutiny analysis. Because under strict scrutiny, if the government has a compelling interest in here preventing domestic partner violence, for instance, the law, nevertheless, if it implicates a fundamental individual right, has to be narrowly tailored to achieve that purpose. And it actually has to achieve not some theoretical achievement, okay? It has to actually achieve that goal. And it's not clear here. And actually, John Lott has put out some information about this. These laws have almost no effect on the rate of domestic violence. And I'm not suggesting that we go back to the tiers of scrutiny analysis. I'm absolutely not suggesting that. I think that's wholly inappropriate. It's just an interesting thought experiment that somehow we've watered down the text, history, and tradition enough already, just 2 years after Bruen, that we're getting the same outcome, that we would maybe a worse outcome than we would have gotten under the strict scrutiny analysis. But nevertheless, like I say, the tiers of scrutiny is certainly not the appropriate analysis. Just an interesting consideration. All right, and then Justice Gorsuch, he wrote separately a concurring opinion. He had a few interesting things to say, but I'll let you read that for yourself. I'm not going to belabor this entire document. It's 103 pages. And actually, I'm sorry, I still had the amber picture up there. Go back to the opinion here. He does say, Gorsuch, I appreciate that one of our colleagues sees things differently, but if reasonable minds can disagree whether 922G8 is analogous to past practices originally understood to fall outside the Second Amendment scope, we at least agree that is the only proper question a court may ask. So he's just saying here, at least we agree on the methodology in terms of, at a high level, that we should not be doing any interest balancing. We should only be looking to text, history, and tradition. He also in his concurring opinion, emphasizes some of the things that this case does not do. Okay, he says our resolution of Mr. Rahimi's facial challenge necessarily leaves open the question whether the statute might be constitutional as applied in other circumstances. And he says in particular circumstances. So even though they said it was constitutional as applied to Rahimi, and they said it wasn't facially unconstitutional as a whole, that means there's no circumstance where it could be constitutional. They said it might, he's saying here, suggesting it might be unconstitutional as applied in other particular circumstances. Okay, and then we have the Kavanaugh concurring opinion, which is mostly a treatise on originalism. It's actually a very lengthy concurring opinion. But I want to get to the Thomas dissent before we close up here. And so I'm going to scroll down to, you see here, I'm skipping over the Barrett concurring opinion as well. But I had highlighted here, it forces 21st century regulations to follow late 18th century policy choices, giving us a law trapped in amber. Okay, and she says this, and this is amazing to me, because that's the whole point, and that's what Bruen said, was that the policy choice was made when the Constitution and the Bill of Rights was adopted. She says, besides imposing a test that demands overly specific analogs, has serious problems. To name two, she says, it forces 21st century regulations to follow late 18th century policy choices, giving us a law trapped in amber. That is exactly the point. That's what it is supposed to do. Okay, so she is just rejecting that purpose. She's rejecting the fact that the policy choice was made when the Constitution was adopted and when the Bill of Rights was adopted. And if the states want and the people want to amend it, they can. They can change the policy. Okay? So she's just flat out rejecting originalism here, essentially. And two, she says, it assumes that founding era legislatures maximally exercised their power to regulate, thereby adopting a use it or lose it view of legislative authority. Such assumptions are flawed, and originalism does not require them, at least when it doesn't reach the outcome that you'd prefer, right? I mean, I think that's the reading between the lines here. She says, to be sure, a court must be careful not to read a principle at such a high level of generality that it waters down the right. Here, that's exactly what the court's doing. Pulling principle from precedent, whether case law or history, is a standard feature of legal reasoning, and reasonable minds sometimes disagree about how broad or narrow the controlling principle should be. Here, though, the court settles on just the right level of generality to reach the outcome that we prefer. That's not what she says. That's my editorializing. Since the founding, our nation's firearm laws have included provisions preventing individuals who threaten physical harm to others from misusing firearms. That's a pretty high level of generality. And like I said, I'm afraid will result in upholding a number of gun control laws that infringe on the natural right to keep and bear arms. Okay. And then finally we have here the Thomas dissent, which I think, like I said, he is the only one who got this correct. He pointed out the significant, not minor, not nitpicking, the significant differences between the surety laws and the going armed laws and the modern analog that the court considered 18 USC 922 G8. And he goes at length here talking about those differences. And he talks about, he does mention the due process issue, but obviously that wasn't an issue raised here. And I think this is extremely important. He reasserts the Bruen standard. He says, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To overcome this presumption, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. The presumption, and this is the important part, the presumption against restrictions on keeping and bearing arms is a central feature of the Second Amendment, and that seems to bother the other 8 justices. That amendment does not merely narrow the government's regulatory power. It is a barrier placing the right to keep and bear arms off limits to the government. And I think it's clear based on this decision that the other justices just do not like that fact. When considering whether a modern regulation is consistent with historical regulations and thus overcomes the presumption against firearms restrictions, our precedents point toward at least 2 metrics: how and why the regulations burden a law-abiding citizen's right to armed self-defense. And like I said, he goes into a lot of the reasons that I've already talked about, that surety laws and the going armed or affray laws are significantly different with respect to the how. And he talks about, this part's really interesting too, he talks about the English Bill of Rights and looking to history pre-ratification. And he talks about the Second Amendment contains no such qualifiers and protects the right of the people generally. He says, in short, laws targeting dangerous persons led to the Second Amendment. It would be passing strange to permit the government to resurrect those same dangerous person laws to chip away at that amendment's guarantee. And this he's talking about here the background where there were laws in England that deprived people of the right to keep and bear arms based on some determination that they were dangerous to the crown or to the government. And so he says it would be ironic if we went down that path here, which was exactly why the Second Amendment was adopted, was to prevent those sorts of issues. And this is one of the important parts here too. He says, although surety laws shared a common justification, the why, with 922 G8, surety laws imposed a materially different burden. Critically, a surety demand did not alter an individual's right to keep and bear arms. After providing sureties, a person kept possession of all his firearms, could purchase additional firearms, and could carry firearms in public and private. Even if he breached the peace, the only penalty was that he and his sureties had to pay a sum of money. To disarm him, the government would have to take some other action, such as imprisoning him for a crime, which is far different, as he goes on to say, than 922 G8. He says, at base, it is difficult to imagine how surety laws can be considered relevantly similar to a complete ban on firearm ownership, possession, and use. Surety laws demonstrate that this case should have been, and I agree with this entirely, surety laws demonstrate that this case should have been a straightforward inquiry. The government failed to produce a single historical regulation that is relevantly similar to 18 U.S.C. 922 G8. Rather, 922 G8 addresses a societal problem, the risk of interpersonal violence that has persisted since the 18th century, yet was addressed through materially different means of surety laws. To make its case, the court studiously avoids discussing the full extent of 922 G8's burden as compared to surety laws. He says, the alternative here that the court uses is affray laws, and he says they are not a fit on either basis because they justify a public harm and they're criminal in nature. He says the court's contrary approach of mixing and matching historical laws, relying on one's burden and another's justification, defeats the purpose of a historical inquiry altogether. And finally, he says, the framers and ratifying public understood that the right to keep and bear arms was essential to the preservation of liberty. Yet, in the interest of ensuring the government can regulate one subset of society, today's decision puts at risk the Second Amendment rights of many more. I respectfully dissent. So, like I said, Justice Thomas was the only one to get this right. He analyzed, he did not, as the court says, look for a historical twin. He simply recognized that the Second Amendment is a barrier to government infringement on the right to keep and bear arms, and that we have to look to the original meaning and understanding, and that this cobbling together an analog, various analogs that morph into an analog that's somewhat similar is not the proper inquiry, and I think is not quite as bad as, I mean, obviously, like I said, this is not as big a loss as it could have been if the government had gotten everything it wanted, but it's certainly a significant loss. And I saw that 2A History posted this on X. I'm going to put this up on the screen. It says, this is a quote from the case, I think is piercing language from the dissent. This case is not about whether states can disarm people who threaten others. States have a ready mechanism for disarming anyone who uses a firearm to threaten physical violence. Criminal prosecution. Most states, including Texas, classify aggravated assault as a felony, punishable by up to 20 years imprisonment. Assuming CM's allegations could be proved, which was Rahimi's domestic partner, I believe, Texas could have convicted and imprisoned Rahimi for every one of his alleged acts. Thus, the question before us is not whether Rahimi and others like him can be disarmed, consistent with the Second Amendment. Instead, the question is whether the government can strip the Second Amendment right of anyone subject to a protective order, even if he has never been accused or convicted of a crime. It cannot. The court and government do not point to a single historical law revoking a citizen's Second Amendment right based on possible interpersonal violence. The government has not borne its burden to prove that 922G8 is consistent with the Second Amendment's text and historical understanding. And I think that that's from the dissenting opinion by Thomas. So the court here strained to uphold Rahimi's conviction for no apparent reason. There were lots of, for such a bad dude, there were lots of other mechanisms, criminal mechanisms, to prohibit him from possessing firearms. And this is from page 31 of the dissenting opinion, page 102 of the entire document itself. Like I said, when we saw Roberts, Chief Justice Roberts was the one writing the opinion, I knew we were in trouble. Here I'm going to put up a post from Gun Owners Foundation. Supreme Court rules against the Second Amendment 8-1. Justice Thomas was the only one to correctly apply the text, history, and tradition of the Second Amendment in his dissent. I wholeheartedly agree. And then there were some statements from Firearms Policy Coalition, Gun Owners of America, and the Second Amendment Foundation. I'll put up the one here from Firearms Policy Coalition, since I already mentioned the Gun Owners of America there on their X page. Firearms Policy Coalition says, today, Firearms Policy Coalition issued the following statement regarding United States Supreme Court's decision in United States versus Rahimi. As we explained in our amicus brief, the federal government has no constitutional authority to impose gun control on peaceable individuals at all, let alone the statute at issue in this case. While we disagree with the court's holding and dispute federal authority to enforce this regulation, we are encouraged that the court confirmed the textual and historical analysis required under its Heller and Bruen decisions. We will continue to eliminate disarmament schemes and restore the right to keep and bear arms through our high-impact FPC law, strategic litigation program, and other efforts. So, FPC and other organizations are looking for, and I think rightfully so, looking for things to be positive about, and that's one of them. I mean, that's certainly something to be positive about, is that the Bruen methodology is still somewhat intact, not to the degree that it should be, but it's a far cry from what the government wanted. They basically wanted to be able to disarm everyone who they considered to be irresponsible, and they didn't get anything close to that, but nevertheless were able to, by taking this unsympathetic plaintiff to the Supreme Court, they were able to, or defendant rather, they were able to make bad case law from a bad case, which is always the risk of a bad case at the Supreme Court, especially with Chief Justice John Roberts. All right, finally here, before we close up, I want to share one more thing. I shared this last week, but I want to share it again from the 10th Amendment Center on X. They say, "We're happy to see the Supreme Court do the right thing by rejecting the Trump stock ban, which they're referring to the Cargill case. Agree, even if for different reasons, but there's still a part of this very dangerous to freedom. Waiting 5 to 6 years for one part of the federal government to tell another part of the federal government that the federal government should stop doing what the federal government was never supposed to be doing in the first place is not the way a free people is supposed to respond to invasions of their liberty. It's a population on its knees begging for scraps." Thomas Jefferson put it like this: "Whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force." James Iredell, one of the first Supreme Court justices, told us how to deal with usurpations of power. "The only resource against usurpation is the inherent right of the people to prevent its exercise. In other words, as long as people rely on the government to limit the government will eventually stop limiting itself." We see that here. The flaw in relying on the government to limit other parts of the government is that the Supreme Court, even when composed primarily of self-proclaimed originalist justices, nevertheless, sometimes, often actually, sides with the government. I'm hopeful that the Supreme Court will get some better news from the Supreme Court with respect to the Loper-Bright case, which is not a firearms case, but certainly challenges challenges the authority of administrative agencies, and I think there's a good chance anyway, do away with Chevron deference and rein in the rogue administrative state, at least to some degree. All right, everybody, I hope you learned a little something here. I hope you enjoyed the show. If you did, don't forget to like and subscribe. As always, you can find us on YouTube, Twitter, Facebook, Rumble, and all the most popular podcast streaming platforms. You can find me on Twitter at Forge of Freedom and at forgeoffreedom.com. All right, everybody, I'll see you next time, and until then, remember, you are the Forge of Freedom.
Thanks for listening to this episode of Forge of Freedom. Be sure to subscribe wherever you heard this podcast so you never miss a future episode. For more information or to connect with Alex, you can go to forgeoffreedom.com or follow him on Twitter at Forge of Freedom. Until next time, remember, You are the Forge of Freedom.